Welcome back, everyone. Today we're diving deep into a topic that touches all of us, yet many shy away from it: end-of-life planning. And to help me today, I have estate planning attorney, Sam, joining us. It might sound daunting, but understanding this crucial process is vital for peace of mind, not just for you, but for your loved ones too. So stick with us, because we're about to demystify it and empower you to make informed decisions for your future. This is Nothing Happens for a Reason. Hey, Sam, thanks for coming on today.
Thanks for having me.
I'll let you introduce yourself.
Yes, my name's Samantha Baker, and I'm an estate planning attorney in Portland, Oregon.
Well, thanks for coming on and being willing to talk about something that I think feels, at least speaking for myself, so complicated.
Yeah.
And also so incredibly necessary to be having these conversations. So
yeah,
I'll just let you jump in and start educating us.
Sure. Well, yeah, I'm so grateful that you thought of this. We've talked prior to your podcast about how important this connection is, but it's complicated and it doesn't have to be. And so I feel really passionate about just educating people, anybody, anywhere, but also younger people and people of our generation, just what estate planning actually is and why I think it's so necessary. And so I wanted to start by just kind of big picture. What is estate planning? Why would somebody need or want estate planning? And I think there are 3 or 4 big buckets. The first big bucket is, I think, something that everyone is familiar with, which is to help control your assets after your death. And so estate planning can provide for where you want your assets to go, who you want them to go to, how you want it split up. Do you want to give to charity? Giving your loved ones after you leave kind of a roadmap for how you want things to go, so that when they are grieving, they don't also have to tackle this insurmountable challenge.
And can I ask a question about
Please.
that? So when you say assets,
Yes.
Are those like just the big things, house, car, or can it be down to, it can be everything, like the plates in my cupboard and my plants?
Yes, it is everything. Assets can be financial. And so we have checking accounts and banking accounts and retirement accounts and investment accounts. Those are financial assets. And then we also have what is called tangible personal property, a very kind of silly legal term, and that's all your stuff. And so that includes this microphone and your plant and your silverware. And typically what we see, especially in younger generations, is that it's all just clumped together as one. There's an opportunity to leave a specific gift, which is, your stamp collection goes to your nephew, or, your prized plant goes to your best friend who gave it to you. Sometimes we'll see something like that. I think that trend is kind of dying, but your tangible personal property is usually lumped together with your assets and will be distributed as described in your documents. And it's usually the same. The people that get your assets are the people that get either your tangible property. And most frequently, all that stuff gets sold or is directed to be sold. And so maybe it's your wedding ring goes to your daughter and something else specific might be left. But overall, that's why you see estate sales. And it's like the personal representative, which we'll talk about, is kind of responsible for selling all of your stuff, and all of the proceeds of those sales will go into the assets, the financial assets that ultimately get distributed. In Oregon, the main person who administers your estate is the personal representative. You may hear that term being executor, same role, just different state descriptions. And so if somebody says, I'm the executor of my family's estate or my dad's estate, it's the same thing as personal representative. The responsibility of that person is to administer the estate as the document says. Yeah. Does that make sense?
Mm-hmm. Yeah.
Okay. So that's one big bucket. Another big bucket is to plan for, some people will say avoiding taxes. I don't want to say that, but it's tax planning. And so in Oregon, and I can only speak to Oregon because that is where I'm an attorney, and all states will have different tax thresholds. There's a federal tax threshold for more high net worth folks, but then there's state tax threshold. In Oregon, it's 1 million. I think in Washington, it's over 2 million. So that's just an example of how different it can be. But what that means is if your estate is over $1 million, anything over $1 million will be taxed at different percentages. And so without going into the details, what that means is after all of your assets are kind of added up, including proceeds from tangible personal property sales, that amount will be distributed to your beneficiaries, to the people that you leave your assets to after debts and taxes are paid. And so if you have, and a lot of folks living in around Portland these days, if you own property, you're already that much closer to $1 million, right? And so a lot of folks are looking at estate taxes. And so if you have a plan that involves a trust and you have sort of sub-trusts built in, there are ways to kind of move your money around, or you could be educated in a way that you maybe gift some of your money before your end of life that doesn't leave your personal representative or your estate paying a lot of money in taxes, but kind of keeping that wealth in the family.
Okay.
And so that can help build generational wealth. Or some people are just like anti wanting their money to go to that when it can go, even if it's $10,000, can that money be distributed to your children or to taxes? And sometimes it's okay. It's okay to pay taxes, and that isn't wrong, but estate planning can be one way to plan for that. So there's lots of ways to move money around in life to prepare for death. And that's just one of the reasons why working with an attorney is really helpful. Okay, so another big bucket is guardianship. And so I have 2 little kids, and it is a really, really hard decision to have to sit and think about, who do I want to raise my kids if something happens to myself and my spouse? Because I don't want anything to happen to myself and my spouse, and I don't want anyone else to raise my children. But accidents happen, and we travel a lot. And what if we're on a plane or a boat, or, God forbid any of that happens. But what are you doing to protect your children, in the wake of that type of grief? And I think a lot of people might listen to this, and even when it talks about leaving assets generally, but if you're from a family that is happy and healthy and together, and there's no divorces and there's no stepchildren and everything's amicable and lovely, that's wonderful. And those families exist. And I think that's getting to be more and more rare. And the fact is, even when things in life feel like everything's amicable, death can change some of that. And so, I work on the litigation side of things too. And that's where you see where things can go wrong. And maybe somebody didn't plan for guardianship because they were like, oh, my sister, who's my best friend and who lives next door, would obviously raise my children. And she knows that I want her to raise my children. But then mom gets involved and has a very different opinion about the way that sister raises her children.
Oh my gosh.
And, and that turns into a family law argument that I don't know anything about. But it happens. It happens in really loving families because grief is emotional. And everyone wants to take care of those kids. And you don't want it to turn into a court battle. And if you don't have a guardianship in your will, the judge would often have to decide who your kids go to. And I think more often we see blended families, and we see partners who live together and who are not married. And we see political divides. Do I want my children being raised by somebody I love dearly but has very different views than I do?
Right.
Do I want them raised in that part of the country? Maybe I, love my sister as much as possible, but I don't want that. I don't want that for my kids. I want a different life for them. And so there's so much to think about, and it's so complicated, and seems like a simple little provision in a will. But if you don't have an estate plan because you think you're too young or you're not wealthy enough and you have young kids, that's something that is missing. So if you were to pass, again, this is assuming that your spouse is also passed, or the children's biological parent is also gone or has otherwise been deemed not fit to raise the child, the will would be the first place. And if not, then it goes to a judge to decide. And so folks can make an argument, like in the example of my sister, which I don't have a sister, so that was a very big lawyers love talking hypotheticals. But an example where my sister is like, I am the person, right? We don't have any other people. I am the person. They can petition to the court and it would likely be approved. But if somebody came out of the woodwork or wanted to contest, or maybe the biological father had a living parent and they want to say, or they at least want like custody or, parenting time, but anybody can petition at that point, and maybe that's not contested and it's easy, but it leaves it open to anybody else saying, no, me.
Sounds like something really important to try to avoid in the midst of that hypothetical kiddo losing their parents. So
yeah, and I think that's what estate planning is for me in general. You're setting your family up to be able to fulfill your wishes, but also to deal with what they have to deal with the least amount of stress. They are grieving. It is really hard, first of all, to take care of things depending on your level of grief. And that doesn't just go away, right? And so if it turns into a family matter or a custody matter, you don't want that. Nobody wants that. And you certainly don't want that for your children. And you also don't want them to have to bounce around. Okay, we're going to live with grandma and grandpa for a little while and then aunt and uncle. And it just makes it easier.
Yeah.
And often attorneys, and this goes for every provision of everything I'll discuss, but a good attorney will plan for a contingency plan. And so maybe I put my sister and her husband, but they decline. Or maybe I'm in an accident with my sister. And so there's a second person listed and a third person listed. And I just said that lawyers love hypotheticals, but it's so true. We really have to plan, and we should be planning for things that will hopefully never come true. The whole thing hopefully never comes true, right? Hopefully my children are adults and well-equipped to take care of themselves when I pass, but you want to plan for the unimaginable, because when the unimaginable happens, that's when those folks need the most support, right? And you don't want them to have to suffer more or struggle through, how do I do this? How do I take care of this? What would they want? How do I know what they would want? And so estate planning really takes care of your family after you're gone.
Yeah.
I think those are I have notes here. I think those are the big buckets that I wanted to talk about in terms of planning, but I will add one more. Estate planning also helps plan for incapacity. And so death obviously is kind of what everyone thinks about, but what people I think don't consider is, what if you're in a car accident and in a coma, or, something else happens where you are incapacitated. You can't handle your finances. You can't access your finances. You can't pay your bills. You can't make medical decisions for yourself. Estate planning considers all of that, and there are documents that can define what you want, what's important to you, who you want to make those decisions, and in the event of incapacity. And we can talk about those in details in a little bit, but I think people think just like assets, who's going to get my money? And there's this whole gap of what happens if you're incapacitated. And again, we never want that to happen, so we don't want to think about planning for it. But it's another type of grief. If you have a spouse or an adult child, or if otherwise a family member who is sitting at your hospital bed and the doctor's asking them questions and they're grieving and they have to decide, people decide when to use a feeding tube or stop using a feeding tube. So those are really big decisions that, again, we don't think that we will ever have to plan for. And hopefully every document I create for my clients, is only used at the end of a very long life. But until then, I think it's important that we all take care of ourselves and our loved ones by making some of these decisions for ourselves and letting folks know what we want. So I think that planning for incapacity is also another big bucket. And then I just briefly wanted to talk about myths, because I think that I've maybe touched on some of them already, but there are so many myths around estate planning that feed into why people don't get estate planning or think that they don't need it. And I think one of them is, I'm too young. Estate planning is for the elderly. That's just not true. It's everything I just talked about. You're planning for hopefully something that doesn't come into fruition, but you're planning for your children in case you pass before they're adults. You're planning for incapacity in case anything happens. And, as we know, we can't control these things. And so it's just planning. It's having a little bit of control over where your things go, but it's also really building up a successful kind of succession for your family to be able to handle in the wake of their grief. And you're never too young. That's not true. You have to be 18 to to work with an attorney. And so once you turn 18, you can get some of that in place. And I think that it's something that college students don't think about. I didn't think about any of this until I went to law school, and I was like, oh, that's really interesting. And the next myth is that you're not wealthy enough. And that's not true either. You know, it's, again, everything we just talked about. It's not about the amount of money. Now, when you do reach a certain level, like that $1 million threshold, your tax planning might change. If you're an ultra high net worth person, you will have different planning. You might have different types of trusts. You might have a charitable trust. There are so many different ways that you can evolve your estate plan as you gain wealth. But whether you have no 401k, $100 in your 401k, or, $500,000 in your 401k, the way that is gifted, which we haven't talked about, but the way that it's gifted is the same. And the way that I would write a provision for guardianship of your children is the same no matter how much money you have. And so there's not a certain amount of wealth that you need to get before you do your estate plan. And when it comes to, your tangible personal property, like you have stuff and somebody is going to need to do something with it. Bottom line, you have dogs, right? Who's going to take care of your dogs? Dogs are like children to people. You don't want anybody to have to figure it out. You want somebody you can put that in your will. You can say, I want this person to take care of this dog and this person to take care of this dog.
Right.
You can leave a certain amount of money to that person so that they have a little bit of money to do special medicine or food or whatever it is. You can leave directions. Like, you can be as specific as possible to make sure that things are taken care of. And that has nothing to do with how wealthy you are. I think there's one more myth. My favorite myth. I believe you and I have talked about this, but I don't need an attorney. I can just do it online.
Oh, yeah.
We love this one. And here's the thing. You could. And will AI take away my job one day? Maybe, probably. I don't know.
All of us.
All of us. I'm not immune to that as an attorney, but it's not there yet. And I mean, it is there. It exists. You can go online and download a will. But what's not there is the relational aspect of estate planning. Estate planning is not one size fits all. Estate planning is about, for me, it's about the relationship. How are your kids? How do you feel about this relationship? How do you feel about this husband? A lot of times I've had clients who have kids and their families are very collegial. It's not the right word, but everything seems fine. But it turns out that we don't trust this husband. We don't like the way he uses the family's money. And the parents, the kids are adults. Their parents are the ones doing estate planning, and they want to say, I want my money to go to this person, but maybe it goes to that person in trust so that their spouse can't access it. There's all sorts of different scenarios. So AI is not going to ask you those questions. Again, maybe one day it will, but a good estate planning attorney, in my opinion, will get to know you, get to know your family, and ask the hard questions. And if you don't know anything about estate planning, but you know that somebody told me I have to get a will, you're not going to know to even think about, oh yeah, I don't trust that person, or they're going to get divorced. They're already getting divorced, but I'm doing my estate planning. And so I might not even connect that that's related, but you never know what people are going to argue about after your death. And AI isn't quite that advanced yet.
And are they holding up in court?
It depends on what the argument is. I think one of the, something, again, at least in Oregon, every state's laws are different. We have very specific execution rules, how you execute documents. And so how many witnesses have to be there, which documents have to be notarized. A lot of people will create a will and then print it out and put it away. That won't hold up in court. Now, there is a statute that one can argue, it was intended to be his last will, and you'd have to pay an attorney to argue it. And if somebody else thinks that they have a right to those assets that are different than how they're described in the will, that person can argue it. And so again, it all will depend on what happens to these dynamics after your death. But if it is signed appropriately, it could hold up. If you print it and you sign it yourself and then you put it away, that's not going to hold up. Not in Oregon, because you need witnesses. If it has lines for witnesses, if it says, if it tells you what to do and then you still don't do it, it doesn't count. If you sign it and then you bring it to a witness later to sign it, that probably doesn't count. There are laws in place to protect assets from creditors, from deceit, from fraud, and a good lawyer, if somebody thinks they have a claim to those assets, a good lawyer could, win that argument if you just print documents off of the internet. And then there are lots of more simple scenarios where maybe that works, but also, is that AI program that you're using sophisticated enough to ask the deeper questions? Does it plan for one guardian, but not a second or a third? Does it, so I think I will always prefer the relational aspect of, if I'm going to go so far as to getting an estate plan because I believe that I need to protect my assets and because I want to take care of my family after I leave, I'm going to make sure it's done right.
Right.
And even if it's, $500 cheaper to do it online, I'm not interested in that. I want it done correctly, and I want to feel safe and secure that I've taken care of my family the way that I want to. And whether or not it holds up might depend on who argues it. That's not a chance that I would want anybody to take.
Yeah. And so is a will something that anytime there's a change in your assets, you need to be updating?
Not always.
Okay.
So great transition. Let's just talk about kind of the documents that would be included.
Yeah.
A will is the first most obvious one. You'll always want a will. Any document can be modified later. And so if you change your mind about anything or someone else comes into your life, there are some laws that support certain things like divorces, or, you and your husband had a kid after you did your estate planning, but that kid's name isn't in there. There are some laws that support that, such that kid would be your beneficiary. But there are, if anything else changes, if you start investing in real estate property, if you start a business, any kind of bigger financial decisions. I have a couple who is in their early 80s, and they did their estate planning 20 years ago. Their kids are now adults and they have grandkids, and the folks that were listed as personal representatives for them are no longer living because they have passed away. Even though they had contingent backup personal representatives, those folks have passed away and their kids are adults now. So nothing in their life really changed significantly other than time. And that was worth totally redoing because every provision kind of needed to be updated. But if you do have one change that you want to make to a will, for example, you would do what's called a codicil, and it's basically an amendment. And so you wouldn't have to pay for an entire estate plan, an entire will redo every time you wanted to make a little change. And the same goes for a trust. So we can talk, I've kind of been avoiding the world of trust, but I want to talk about that next. But the same goes for a trust. You can make it's a hefty document. It costs more than getting a will because it takes more time and it's more complicated, and you want to explain it to the clients and so they know what it is and how to fund a trust, which I'll mention. But you can just do an amendment. You can just, if one thing changes, you can change it. If you change your mind, or you're like, oh, I forgot about that wedding ring, it was my grandma's, I don't want anybody to sell it, there's a simple memo you can leave with your estate planning documents. So I think a good kind of rule of thumb, if you have a relationship with an attorney, is to be like, hey, this one thing changed. How does this change my estate plan? And the attorney can say, it doesn't significantly. Just write a memo and sign it, or let me draft you a quick amendment to make sure that we make the changes that you want to make.
Okay.
Again, probably something that the internet may or may not tell you those options, but without, if you call the attorney you worked with previously, they can go to your file and they, can kind of remember what you guys worked on and remember what your goals were and say, this is what I recommend that you do. So anytime a big change happens, I would recommend that. So a will is the first document. The other thing that I haven't discussed is a trust. And so I think that more people have trust than need trust, but there are lots of great reasons for trusts. Some people might kind of want more privacy around their money. Some people ease of administration after death. And so there are reasons for a trust, but you want to talk to your attorney to see if it makes sense for you. Big picture, when you die, your will goes through what is called probate. And so another myth, let's just throw in another myth, is that estate planning avoids probate. This is not 100% true. If you have a will and no trust, it still has to go through probate. Wills go through probate. So having a will does not avoid probate. And also probate is not a bad thing. People talk about avoiding probate like it's necessary, but it's a court ordered process to which your assets get distributed after your death. If you don't have a will, if you pass away without any estate planning, every state has different laws of succession. It's called intestacy laws. And we have a statute that says if you die without a will, it goes to this person, and then this person, and then this person, and this person. And so, and that, I'm not going to get into the details because it's complicated, but if you die without any estate planning, it doesn't just automatically go to your partner because you are living with them. It might go to your parents if they're alive, or it might go to, your sister if that's where your family tree lines up. And so if you die without a will, there's a way that the court distributes the wealth, but it might not be the way that you want it to be. Now, if you get a will and you pass away, you still have to probate it. So the court still has to approve all of sort of the moves that the personal representative is taking. If it's a will, if it's not contested, if nobody's arguing it, it's not that complicated, big picture, but the court will just say like, yes, okay. As long as everything makes sense, as long as all the actions are taken are what the will says, but the court still has to approve. And it's still a process. And most importantly, why people hate this process is because it takes very long. First, because the courts are overwhelmed. But there's a period of about 4 months, at least in Oregon, where folks can contest it, or creditors can come after it or make a claim for, this outstanding bill. And so somebody dies, their personal representative has the will. They know that they are the personal representative, which is the person who is named in your will to administer your assets after your death. And they file a petition. They work with an attorney. They file a petition. So they've started the probate process, but then they have to wait for 4 months. So during this time, you can't do anything. You can't distribute the money. You can't use the money to pay creditors. You can't do anything. People hate that because there's a real lack of control. People get mad at the attorneys. People get mad at the system. And it's frustrating. It's really frustrating. But we have to give the opportunity for somebody to say, no, that's not a real will. It wasn't signed. It was drafted off of AI. There's no signature on that will. She told me that she wanted me to get her property. I'm a creditor. She owes this much. We have to make space for that. Otherwise, it'd be really easy to just draft a piece of paper and sign somebody's name on it and say, this is their will. And the court is not just going to say, okay, it looks like a will. We have to give, the family an opportunity to contest it. And that being said, caveat, only certain people can contest a will. You can't just kind of come out of the blue. You have to be, a potential person who would receive. And so just keeping it very simple. But yes, that takes time, and it can take, and that's just 4 months, and then it can start. And depending on the person's assets, it can take months. So the probate process in general, you might still be a year after the person died, and you might still be administering their estate. Selling real property depends on the property, how fast that goes, right? And it depends on where it is, and do you have to get it appraised? And, there are so many things that happen after a person's death, and to go through probate prolongs it, and people hate that. And it's frustrating, and you have to pay attorney fees the whole time, and those will likely come out of the estate. And so people shy away from that. So going back to a trust, what a trust does is avoids probate. Okay. So estate planning in general does not avoid probate. Creating a trust avoids probate. What a trust does is takes the court system out of the process and says the named trustee is now the trustee of this trust. And so if you created a trust on your own, you would be the trustee. And your successor trustee, if it's me, when you die, I'm automatically the successor trustee. So I automatically have the power to access your accounts. There's a process, right? I have to present a death certificate to the bank, and I have to present the certificate of trust that says that I'm the successor, blah, blah, blah. But I can do it, and I can do it as soon as those documents are in my hand. And then I can act. And then again, depending on the provisions, sometimes there's sub-trusts I give to my children, but not until they're adults or not until they're 30. And so the trustee might have a responsibility for a really long time, depending on the distributions. And the trustee may or may not want those responsibilities. And so we also build in successor trustees and alternative trustees, because if you're managing maybe like your niece's trust for 15 years, you also have discretion to give them money as they might need it for health or, life maintenance or education. So a trust can have all these different provisions in them, and the trustee is responsible ultimately for doing that work.
So is a trust in place of a will, or do people have both a trust and a will?
Great question. So people also have both.
Okay.
Good planning, which AI may or may not do for you. This is, I think, the thing that goes wrong in most trust planning. Often an attorney will do a trust, and then the person says, I have a trust now. In actuality, you do technically have a trust, but you have to do work to fund your trust. And so if you own a vehicle that's just in your individual name, the trustee, even though they're the trustee and even though they say have access to your accounts or they can, distribute your assets, they can't distribute the car that's in your name as an individual because it's in your name as an individual and it's not an asset of the trust. And so what we have to do with our house, with all of our bank accounts, we have to change the name of the things that we have ownership of into the trust.
While we're still alive.
Mm-hmm. An attorney can't do that for you. A good attorney will help you and will guide you and will give you kind of drafts. We create drafts to say, Dear Bank of America, this account ending in these 4 numbers, I just created a trust. Please transfer this from my name into my trust name. But the bank doesn't want to hear from us about that. You have to go to the bank with your certificate of trust and hand it to them. And so funding a trust is a lot of work. And often, I always see, you can kind of see in couples, there's usually one who handles the finances and one who doesn't. And especially in older folks, if they're, around 80, you're saying, is this something that you want to be able to do? If their spouse has died and their spouse is the one that handled all of that stuff, it might be a really overwhelming process. And you can, have your adult child go with you and help you. And there's all these ways to do it, but your attorney can't help you. Your attorney can tell you what you need to do. But unfortunately, what we also see is that some attorneys don't. And I particularly right now have clients who thought that they have a trust. They do have a trust. They signed it. It doesn't say what they want it to say, which is one problem, but also they didn't fund their trust. And so their real property is in their name as individuals and their bank accounts are in their name as individuals. This doesn't help the trustee. And so what happens is there are things in your individual name still need to go through probate. So the solution to that in the estate planning world is to create a will. It's called what we call a pour over will, because we say anything that's left over gets poured over into the trust. And so the will is very simple. It's very straightforward. Unless we also add things like guardianship, which would likely be in your will. It will say anything that's extra goes into the trust. So eventually the trustee has the power to then, whether it's sell the car and those assets go to be distributed into the rest of your estate to then be distributed to your beneficiaries. The trustee can now do something with that car. And the will, though, still has to go through probate. Okay. Because the will always have to go through probate. What the court will say is it's easy. And so the court will say yes, this is a valid trust. Again, if it's not contested, yes, this all looks valid. Yes, your stuff goes into the trust. And then the trustees still then kind of have to do some of the paperwork because you still have the deed to your house. You still have the title to your vehicle. And these things need to be updated. And so either maybe the vehicle gets sold, but maybe the house was to go to the kids and stay in trust, depending on what the plan is. It's more complicated for the trustee if you don't put everything into your trust. And so some folks are walking around out there thinking that they have a trust. And while they do on paper, It's a legal trust, and it would work and it would be in effect if they funded it, but they haven't funded it. And so they likely have a pour-over will because that's kind of the standard package. But that, even though they have a trust, that will would still have to go through probate, and all of those individual items would still have to be moved over into the trust.
And so, and I'm just trying to wrap my head around all of this because I know more now than I did.
It's complicated.
25 minutes ago.
It's complicated.
So is the only reason somebody would do a trust over just a will so that it doesn't have to go through probate and their trustee has access right away? Like, are there other benefits of why somebody would do a trust?
There are other benefits. I think privacy is a good one. Anything that goes through the court is public record.
Okay.
And I recently had this conversation. Some attorneys put date of births of their children on wills and some don't. And I recently had this conversation and an attorney was like, why would you do that? It's public record. And I was like, because it identifies the person, right? Like in terms of if you're trying to plan for like if this is contested, it just more specifically identifies the person. You're like, yeah, but it's public record. So attorneys have different feelings about that, but it is public record. And so sort of maybe if you have more wealth or if you have generational wealth, you might prefer to keep it private.
Got it. Okay.
I think that's another big reason. Ease is a big reason. Trusts also can provide for more protection from creditors. We don't need to get into that. You still need to pay the bills of the decedent, but again, it keeps your assets a little bit more protected. And I think that if you do it correctly, it's a good idea. I don't think that you necessarily need to do it if you are somebody who thinks that they can't afford estate planning or thinks that they don't have enough wealth for estate planning. Hopefully I've debunked that myth, but you don't have to do the most expensive package. You don't have to do the most extensive planning. You can just get a will and make sure a couple of the simple provisions are taken care of. Something else, I'll add a caveat. I wasn't going to get this layered, but in a will, you can also create subtrusts. And so a will is called kind of like a testamentary instrument. And so you can create testamentary trusts, which means, in the example, if I have 2 minor kids, if I pass away, I want to leave money to my kids, but they don't have bank accounts and they're children, and what would they do with that money? And so I would leave it in trust for them. And in trust means that there would be a trustee assigned to that testamentary trust. And so some people get kind of tripped up by the language. They're like, we decided to do a will, but now I'm seeing that I have to name a trustee and there's going to be this trust. But it's basically a way to hold the money separately and have the trustee kind of, again, manage it for the child's lifetime. And that is separate than having a trust and having your assets in a trust. But basically that child in that example would have a trust in their name. And if the will is done, kind of typically the trust has a date of termination or an age of termination. Mm-hmm. And so it's not forever. And it's not that that person now has a trust and they have to fund it with all of their assets. Mm-hmm. It's just kind of like a holding pot for the money until that person reaches the age of whatever the decedent decides. Okay,
so when I've heard people say like, oh, when I turn 25, I get access to the trust. That's kind of what you're talking about.
Yeah, and those specifics can be in an actual trust as well. Okay. So, and we recommend it, especially if they're minor children. Mm-hmm. Even age of 18 is not really recommended. What 18-year-old knows how to use money wisely? And what if we're talking about $1 million? Do you really want to give an 18-year-old $1 million? Most of the clients that I have worked with don't, and they want to give X amount for education or X amount for a down payment of property, or 50% of it when they turn 25 after they've completed an education. You can make it as specific as you want. And then the trustee named would be responsible for using discretion. Is this an education? Is this a prudent investment? Is this property that we want to give the money to you for a down payment? Is it a prudent investment? So the trustee has they're called a fiduciary. They have a lot of fiduciary responsibilities to make sure that they are distributing the money as the decedent wanted. And we see a lot of litigation on that end too, of trustees not doing their duties. There's a whole bunch of other stuff that they have to do in terms of reporting, and it can be a big job, and you need to kind of nominate somebody who's up for the role.
Mm-hmm.
And so yes, you can put all those provisions in a trust as well. We usually see those around minor children, or if you have a disabled child, there can be, a specific trust for special needs, and you can kind of make the terms however specific you'd like, and then the trustee is responsible for carrying that out.
Okay.
And then kind of to wrap up what is in the estate plan. So we have your will, your trust, or your pour over will if you have a trust. But then there's the other kind of important healthcare documents that we talked about. So what's called an advance directive in Oregon is attorney doesn't actually draft that. The Oregon Health Department, I believe, created that. Oregon Health Authority.
Mm-hmm.
You can find it online. You can download it right now. You check the signature process if you're not working with an attorney. But that document is the one where you can put your wishes in the instant of incapacity. And so, do you want a feeding tube? Do you want to be, if the doctor declares you brain dead, if you're in a coma, what do you want in these scenarios? Some people have religious reasons that they don't want to be, plugged into a machine, so to speak. And it leaves options for all of that. A lot of it, most of the time I've worked with clients who, don't fill in the open-ended box. But some people say, my religion is this and I want this. And then the most important thing is that you can name a healthcare representative. Again, typically we see it's the spouse, and then typically it's the adult child. But if you don't have those things, it is your best friend, or if you're in a relationship and you're not married and you want that person to have the kind of the spouse line, it's even more so important to have these documents, because otherwise, if there's no legal reason that the doctor can see that you're allowed to be privy to privacy information that's otherwise covered by HIPAA, your partner's not going to be allowed in the room. And so having the appropriate documentation to say, I'm this person's healthcare representative and this is what they want. And something that is really helpful about that document too is then that person doesn't have to make the decision. So something else that's really important about this advance directive is it goes back to our conversation about grief. And so if you're incapacitated and your partner or your spouse has to make these decisions, they might not be able to. They might not want to.
Yeah.
And if you're really sure of not wanting something, and maybe you've had this conversation with your partner or your spouse and you say, I am not interested in being plugged in for 6 months and us paying for all of that. And there's, if the doctor is saying there's no chance of recovery, don't be stubborn, right? And you can have these conversations, but will that partner or spouse have the power, or if they have the power, will they have the internal power to make those decisions? Grief can make you think all sorts of things, as you know. And so having a plan in place and having the conversation with your healthcare representative of this is what I want and this is why. And it's just guidance in the same way that you would guide where your assets go. It's just guidance for the people that you leave behind to help them make the decisions that they don't want to make. They don't want to have to make, right? We don't want to be in this position anyway. We're grieving, and now we have to make these really hard decisions. And so it's part of the roadmap to help them do so. And then the other document is the power of attorney, which you mentioned earlier. That is similar in that it's the person who's responsible if you're incapacitated, but it relates to your finances. And healthcare representative is all of your healthcare decisions. So if you're deemed incapacitated, you have some sort of note from your doctor, the power of attorney does. It's basically a living document. So they can take that document to the bank with the proof of your incapacitation. And the document typically does and should define incapacity. And so they bring that information to the bank account so that they can then access your bank account to pay your mortgage or pay your rent or your student loan or whatever it is. And even if it's your spouse and you're legally married, but that spouse isn't named on your account, it's your sole account, they can't get in, they can't have access. And so if you're incapacitated, that money is stuck in there. So the power of attorney is a living document, and it comes into effect when you're incapacitated. If you die, the power of attorney is no longer active. And so there's also these scenarios where somebody is named as power of attorney, but not as the personal representative or the trustee. So you'll have, if you are, say, in a car accident and you're incapacitated, you have one person managing all of your finances, and then you die, that role might shift. And it is what it is, and that's okay. Sometimes you have somebody who's really great with finances, and you're like, this person will be able to take over this role, or this person is a CPA, or this person's an attorney. Some people make the decision based off of that, often when they don't have a spouse or a partner. But there's also, there can be confusion and maybe frustration for the people who are named when it is different. And so again, that's okay, but it's maybe something that you would want to tell everybody to give them a heads up. You're not obligated to tell any of the named people in these documents what their role is. You don't have to tell your personal representative that they are a personal representative. You don't have to tell your power of attorney that they are a power of attorney. I recommend that you do.
Yeah.
I think that people, it's hard to talk about death. It's hard to think about death. You know, those are the conversations I have every day. But preparing, you know, the point of estate planning is preparation. And so if you're going so far as to prepare your family to help with ease after your death, take this extra step, have a hard conversation and say, at the very least, say my estate planning binder is in this fireproof box and here's where I keep the key. You're your personal representative and here's my attorney's name. You don't have to go to the same attorney, but here's all the information that I can give you. And so I jumped around a bit, but yes, so power of attorney is finances when you're alive. If you are a power of attorney of someone and they're incapacitated or otherwise there's a necessity for that, it dies when they die. And so even if you are responsible, even if you are their power of attorney, you are no longer when they die. Now, if you are also their personal representative or trustee, you still maintain that position, but you're no longer called the power of attorney. So the term doesn't even apply to you. And I think that is something confusing for folks. So just good to note, if you are named as the kind of the next role, you still take on all the same responsibilities, just in a different way. Yeah.
So helpful.
It's a lot, and
it is
so
a
confusing.
lot. This world normally feels too overwhelming and confusing to me. My brain doesn't work this way. You know, I didn't go to school for it.
Yeah.
And I feel like I understand it so much better now. And so, I think the way that you explained it was very digestible.
Good.
And it's a lot to think about.
It's a lot to think about. And I think I just encourage everyone to talk to an attorney about it. Don't ask for free advice. We can't give that, but hire an attorney and talk about what your needs are. Maybe they're really simple. And it's something that an attorney can take care of and you don't need to think about it for another 10 years. But I love kind of bringing on that type of client because then I can check in with them in 10 years or 5 years. How are your kids? Any marriages? Any divorces? Any significant changes? And, you know, a proactive attorney will do that and kind of be there with you through those changes. And you, in 10 years, you're not going to be thinking about, do I need to do any updates to my will? Maybe if something significant happens, you'll be curious about it, but then you'll know who to call. And that person will already have kind of a base knowledge of where you were at least 10 years ago. So why not establish that relationship? And I think the why not is obvious. It's expensive. There are attorneys who are more expensive than others, and there are bigger law firms, and there are solo practitioners, and you just need to do your own research and see what you're comfortable with. But why not have somebody who is there to help you understand things like this? And then down the line, when something changes, it's a phone call and it's a simple amendment, or it's an attorney saying, no, we already put that in place and you're good to go. And I think having that peace of mind and allowing your family to have that peace of mind is a really, really important step to helping them throughout the grieving process. It's not going to make the grieving process any easier, but it's also not going to make it harder.
Yeah, that's super important.
Yeah.
Thank you so much.
You're welcome.
I really appreciate you being willing to come on today. Yeah, I can tell you're passionate about it. And again, it's been super helpful for me. So I'm sure it's going to be helpful for a lot of other people. So
thank you for having me.
Yeah, thanks, Sam. So that's all for this week's episode on Nothing Happens for a Reason. Thank you for being here and listening. We'll be back with a new episode next Thursday. And if you find value in these conversations, please subscribe and consider leaving a review. It truly helps others find our community. And if you know someone who might find solace or understanding here, whether they're experiencing grief or seeking to better understand grief, please share this podcast with them. I appreciate your support deeply. Until next time.